We are as good as any other person. Speak up and let other disabilities know we can help other people to grow and stand together on our big issues. People with disability can work hard for things they know are good for them. Thank you, ladies.
Thank you, Chief Justice. We have tried to supply the book on disability rights in the law and the NHRC manual on Dalit rights. If anybody hasn't got those books, we have extra copies and we can supply them. So we just courts, mainly the Delhi High Court, since the year 1976. Before he was elevated as a judge of the Delhi High Court in the year 1999. Apart from his many illustrious judgments, Justice Sen is one of the judges who has contributed very positively to the emerging jurisprudence on the disability rights in the country. We rely on several judgments that have been delivered by him on disability rights. I now invite Justice Sen to speak on the landmark judgments on disability rights under the Constitution of India.
Thank you. Dr. Shiva, Justice Shah, Chief Justice of the Chennai High Court, Justice Khan, Chief Justice of the Jammu and Kashmir High Court, and learned brothers from high courts all over, ladies and gentlemen. Justice Shah said that the judiciary is specially responsive towards the rights of the disabled. I wonder why that is so. Perhaps if you were to ask the opinion of 10 lawyers, at least 6 of them would say that judges are mentally disabled. Perhaps that is why. But it is true. As I see the statutes that have come out, I find that they are mainly cosmetic. They don't achieve anything. Or if they achieve something, it is so marginal that it is not a remedy. Whenever I watch the National Geographic or the Discovery Channel, you see that predators go after the disabled. They go after the newly born. And it always leads to distaste. If we are expected to rule the animal kingdom, and if we are something better than animals, one of the manifestations of that must surely be the desire, the deep-rooted obligation to look after not only the newly born, the minors, but the disabled. I cannot believe that law can serve its purpose unless this particular goal is foremost in mind. I think a lot of what I wanted to speak on has already been spoken. I think there is an overlapping of the two topics, but as usual, Justice Shah has presented a conspectus of the law. I would like to start with a few topics. The first question is, Justice Shah had mentioned that 48.5% of this category are visually impaired, 26.9% suffer from locomotor disorder, and 5.8% suffer from hearing disorder. Now, in spite of this disparity in the handicaps, we find that the Act mentions a minimum, and I will emphasize a minimum. It mentions a minimum of 3%, which has to be distributed in 1% each. The effect is, again, a disproportionate, even if the act is to be looked at, a disproportionate distribution in the benefits of the act itself. When we come to the landmark judgments, I would like to start with Narendra Chandla's case. This is SCC 1994 4 SCC 460. This is a judgment which was given prior to the coming into the Act. The court went into Section 14, into Article 14 and Article 21, and held that Article 21 protects the right to livelihood as an integral facet of the right of life. When an employee is afflicted with the unfortunate disease due to which, when he is unable to perform the duties of the post he was holding, the employer must make every endeavor to adjust him in a post in which the employee would be suitable to discharge his duties. Asking the appellant to discharge the duties as a carrier attendant is unjust, since he is a matriculate, he is eligible for the post of LDC. For LDC, apart from matriculation, passing in typing test either in Hindi or in English at the speed of 15 or 30 words per minute is necessary. For a clerk, typing is generally not a must. In view of the facts and circumstances of the case, we direct the respondent board to relax his passing of the typing test and to appoint him as an LDC. Now, admittedly on the date when he had the unfortunate operation, he was drawing a certain salary. Necessarily, therefore, his last drawn pay has to be protected. Now, this decision comes before the Disabilities Act. There is a tendency that to give relief only in the background of the Act. My thesis would be that we don't need to do that. And that stems from the opening statement which I made, that the Act is really cosmetic. Now, if we can go back prior to the Act, then a number of things come into place. First of all, do we adhere only to the 3%? Or given in certain circumstances, should we go over that? Secondly, are we constricted by the Act only to give relief in these three categories or the other categories? Justice Shah had mentioned about a nurse suffering from schizophrenia. I'm not sure whether you said the single judge had given that judgment and it was overruled or whatever. If the prevailing view is that relief can be given even to those persons, then either we are going beyond the Act or we are falling back under Article 14 or Article 21. I had been faced with a similar conundrum. The question was, the person was serving in the Indian Airlines. He did very well until he suffered a heart attack. Thereafter, he was found not to be good enough to fly planes. That was understandable, naturally. The safety of passengers must be foremost in mind. But what happened was that continuously he was passed over from promotions. There was really no effort made to find out an alternate post into which he could be appointed. Going back to Chandla's case and to the Constitution which surely will prevail over any other statute, I had held that we should view the definition given so far as disability is concerned under the Act as only inclusive, and therefore give the benefits or further distribute them to persons who suffer from any other kind of disability which is keeping them from performing the duties to which they were appointed. That view has not found favor, mainly on the ground that the definition does not cover it. Actually, for me to tell you about case law is very presumptuous. I think we all know the law very well, and therefore perhaps we can achieve much more by having a more interactive session. Now, in Narendra Chandla's case, we've already seen that there was an exemption which was granted. This person was not permitted, was not pushed under the rigor of a certain examination. I would advocate that we need not, that we should try and give a wider meaning to disability of the Disabilities Act. One which readily comes to mind is Rora Back versus Great Eastern Casualty Company. This is a US case. And disability there is defined as absence of competent physical, intellectual or moral powers, impairment of earning capacity, loss of physical function that reduces efficiency, and inability to work. The reservation case has been mentioned already by both the learned speakers before me. Again, I feel that if 50% reservations and above can be given to scheduled castes, scheduled tribes, to economically backward sections by Parliament or by the central government, is that perhaps because they are more concerned with voting rights and their particular electorate, and this particular fraction of a segment of society is not so vocal? Why is it that that this abysmally low 3% is set aside? In a case against the Delhi University, the question which had arisen was whether locomotory disability should be restricted only to 1% as per the Act. The policy of the university was, and the medical council, was first of all not to extend this to blind students. I don't know why that is so. I don't agree with it. But that was not the main challenge. The challenge was that there were persons beyond this 1% category who came to court saying, if you can't fill up 3% under the 3 different categories, kindly fill up more than 1% for the disabled. I found that there was no reason why this particular embargo had been placed, and ruled that the 3% is a minimum amount. The Act also says that it is a minimum amount, and that therefore you can well go over it. The other large segment of cases which have come up on the implications of the Act is on the right to prematurely retire a person who suffered from any disability. The first, as far as the Delhi High Court, again there must be a plethora of precedents from different high courts, but I will mention only a few. The first decision which I could come across on this issue was given by Mr. Sikri. He will be here later in the day. And his view here is that Section 47, in clear terms, mandates that no establishment shall dispense with or reduce in rank the employee who acquires the disability during the service. Even if he is not suitable for the post he was holding as a result of the disability, he is to be shifted to some other post with the same pay and service benefits. Of course, this is really implementing the views of the Honorable Supreme Court. even when even when he cannot be adjusted against any other post, he is to be kept on a supernumerary post until a suitable post is available for till he attains the age of superannuation, whichever is earlier. The intention of Section 47 is clear and unambiguous, namely, not to dispense with the service of the persons who acquire disability during their service. The purpose is not far to seek when the objective of the enactment is to provide proper and adequate opportunities to the disabled in the field of education, employment, etc. It is obvious that those who are interested in employment should not be uprooted when they incur disability during the course of employment. Now, most of us would have come across a resolute attempt by most of government organizations. Again, this is another question. I suppose it has ramifications as wide as extending benefits of reservations, or imposing the benefits of reservations of scheduled castes and scheduled tribes to the private sector also. But the Act restricts the application of benefits to disabilities only to government service, to government offices, which I find is again cosmetic. It doesn't achieve what it ought to achieve, because disabilities is something which, if we are human beings, we must achieve to reduce to a level playing field. I continue. Therefore, their employment is protected even if if destiny inflicts cruel blow to them affecting their lives. Even if he is not able to discharge the same duties and there is no other work suitable for him, he is to be retained on the same pay scale and service benefit, so that he keeps on earning his livelihood and is not rendered jobless. This view has now been affirmed by the division bench, and in a connected matter has been affirmed by the Honorable Supreme Court. This matter was not taken up in appeal. The appeal is from a case called Kamarpal Singh versus GTC, where the Supreme Court holds, we have heard learned counsel for the parties, of the opinion that it is the duty of respondent number 1 to employ the appellants in a class 4 post. If no such post exists, then by virtue of Section 47 of the said Act, as a supernumerary post shall be created within 8 weeks from today, and employment given to the appellant with such relief as the appellant may be entitled to. So again, where the legislature, in my view, where the legislature has failed or has not considered it important enough to give adequate relief on this very, very important issue, it is the courts which have come to the aid. The courts have gone to the extent that reinstatement is possible even after premature retirement has been granted, and that if there is a problem about having to adjust retirement benefits, well, do so against the salaries which have now to be paid. I don't wish to repeat judgments which have already been mentioned earlier, and if I may just close by reading out a very good and well thought of digest of the cases and the principles by my colleague Justice S. Ravindra Bhatt. He writes Section 47 for consideration in a number of cases by this court. It has been held that it applies regardless of where the employee incurs the disability. It acquires primacy and can be invoked without application of latches. Its benefits have to be given even if compensation is paid for premature retirement of an employee. The position emerging from the various authorities are broadly summarized below. I'm saying this because so many of us are faced with having to decide cases in a hurry. Lawyers are not always as diligent as they should be on this matter, this particular judgment crystallizes the position. One, latches cannot be set up to deny relief since the Act is a beneficial legislation. This comes from Kishan Chandra versus ETC. Two,
the citations.
yes, I'll give you a second. This is 2005, Roman 7, AD, Delhi, 599. 2. The provisions of the Act. This may be a local publication. We can request the organizers to make photocopies and available for whoever it is, so whoever would like it. 2. The provisions of the Act have to be given effect to in respect of grievances that arose before enactment of the Disability Act. This is Vijender Singh versus so-and-so. 3. The provisions categorically enjoin every employer not only to retain and desist from discriminating employees suffering from impairment, but also to place them in other posts, without depriving any service conditions or benefits if they are able to function in their posts. This is Rajveer Singh. Construction of the Act should be made in the light of international conventions. This is also the division bench which I had referred to earlier of the Delhi High Court, authored by Justice Sinha, whose lordship then was our Chief Justice. Reinstatement possible even after premature retirement and grant of compensation. What I would like to emphasize in this gathering is my heartfelt difficulty in restricting the benefits to disabled, firstly to 3%, and thereafter to only the categories which have been mentioned there. I think disabilities have to be given a much wider meaning. Wherever we come across any kind of disability, whether it's a heart patient or it is a cancer patient or it is a schizophrenia. Schizophrenia, of course, comes under the Act. But even if it is beyond that, as a judge, I find it difficult not to grant relief. And the possibility, as I see it, is to go back to the judgment, Chandler's judgment, prior to the coming into effect of the Disabilities Act, peg it to Article 14 and Article 21, and say that relief has to be given to these persons, regardless of the fact that they have not been covered by the Act. I think I need to circulate a list for your signature at the end for cruelty to judges. We've had a frantic filing in the court because we are ending up now, and I couldn't do more than trying to collect some of the judgment and give you this particular view of life. Thank you for your attention.
Thank you, Justice Sen. Justice Sen suggested that the session be more interactive. We made a minor change in the schedule. We call upon the Honourable Justices to share their experiences with the law. And I would request Justice Patil to chair the session. For the next half an hour, we're inviting interventions from the floor. And Justice Kaul has just arrived, so his presentation will follow. I invite Justice Kaul on the dais, please. So, for the interventions from all the justices.
Hello. With the permission of the Chair, my intervention is in respect of the presentation made by Justice Vikramjit Seth. Thank you, Justice Seth, for the very critical view of the enactment. You have made a comparison between the reservations provided in favor of the Schedule Caste and Schedule Tribes, the backward classes on the one hand, and the disadvantaged people on the other. I think this comparison is unsustainable for three reasons. Firstly, reservation provided for Schedule Caste, Schedule Tribes and backward classes is on the basis of a historical social disability suffered by them for ages, while the disability under the Act is not comparable to such a historical disadvantage. Secondly, the rights in favor of scheduled caste, scheduled tribes and backward classes, they are class rights, as against the disability persons' rights, which are individual rights. Thirdly, even the scheduled caste, scheduled tribes and backward classes have not been given their legitimate share, thanks to an arbitrary rule invented by the judiciary, imposing 50% ceiling on the reservation. While the population of the scheduled caste, scheduled tribes and backward classes could be anywhere around 80% of the population, the reservation is provided. Scheduled caste will be about 17%, 8% scheduled tribes, and about 55% backward classes. So the reservation provided is also inadequate even to scheduled caste and scheduled tribes. Therefore, it will be uncharitable to say that it is because they have votes that they are given 50%. That itself is a great injustice. This is my intervention. Thank you.
First of all, I don't think the judiciary is against, in any way, is against the scheduled caste, scheduled tribe. I think you won't find a single person who will support you there. The difficulties which are being faced on the political level or even on the judicial level is to balance the resources which are available. You, speaking for myself, if there is 100% reservation, then there is going to be an upheaval. I think if you go back into history, the US exposure. Of course, you must have a lot of knowledge on this. Your point is well taken. The rights which were given to the blacks, or to use a less, but to use the word non-whites, didn't come out of the legislation. It came out from the decision of the US Supreme Court, which was faced with the possibility of rampant civil disobedience and civil disturbance. Secondly, I have great difficulty in accepting your statement that disability is something recent. If there is something recent on the time scale of civilization, it has to be the discrimination against the scheduled caste, scheduled tribe. If you go back, this is a recent, comparatively recent phenomenon. It comes in maybe 300 BC, not beyond that. Disabilities have been suffered right from the beginning. Disability is equated even in the way you respond to your children. If there is one child who is not as proficient or is not as intelligent as the other, I think there is no parent who will not reach out. On a personal level, I have told my children, if A is not doing as well as B economically, don't expect me to leave the same amount to you as a legacy. It's not because there is any dearth of love. Love is the same. But what you're trying to do is actually bring about equality. And that is why I say we don't need to look at the Act to bring about this to think of how to help the disabled. It has been there in Article 14, it's always there. Secondly, it's so technical, you will know it. Are you giving lateral adjustment? Are you giving vertical adjustment? Surely, if you want 80% reservations for scheduled caste, scheduled tribe, why should there not be a preference for disabled within them? But that will not be acceptable. Because the moment you get a right, what you want is that right must be for myself. As I see it, if you say only the visually, the hearing impaired, which are only say 6%, why should they get 1% where the 4 times the number are visually impaired? These are injustices which have to be leveled out. Now, what I said was that within the reservations which have been set apart for Schedule Caste, Schedule Tribe, backward, economically backward, why should the disabled not be considered as a predominant part of the economically backward? Because we know they can't look after themselves. They have to always fall back on some support. Justice Shah says that support even does not come forward from the families. But there is a resistance even amongst scheduled castes for sharing this particular cake from persons within their own group who may be disabled but don't have a vote, don't have the same power. That's my view. I may be wrong.
With the permission of the Chairman, may I ask a question?
May I ask one question? You see, as per the Indira Sahni's case, the reservation shouldn't exceed 50%. Two questions I would like to raise. One is that whether this ceiling limit would apply inclusive of the reservation of physically disabled person. The second is that for each physical disability, 1% is being reserved by the state, total 3%. The normal case law is that if on A reserved category the seats remain vacant, it goes to general category. Now, can this be transferred to the other physical disabled capacity? Since Justice Patil was for the Supreme Court while upholding that 47 is a mandatory, I would like to have the views of Justice Patil. Even other members on the dais can also. Yes.
It's not inclusive of 50%. It will not be included in 50% because 3% is in every segment. 50%, I mean, when there is a reservation for backward classes to the extent of 50%, amongst the backward classes, there is a reservation of 3%.
No, because while upholding this view in Indira Sahni's case, the Supreme Court said that if the reservation exceeds 50%, it may lower down the efficiency in the administration, and therefore with a view to maintain this, it should not exceed 50% with a view to provide opportunity to the other class also. Now the only aspect is that would it include this 3% or it will be in addition to
when there are 50% open candidates, amongst the open candidates, 3% will be taken from the disabled category. Amongst the 50%, 3%, amongst the 50% of backward classes, 3% will come from the disabled category. So there is really,
so,
to look at it from a different
in each reservation 3%.
3%. That's the logic.
No, but in our state it is the 3% generally in addition to this backward class and scheduled caste OBC reservations.
Honorable Chairperson, may I offer a small piece of information?
Yes.
Thank you, sir. Thank you, sir. Sir, Honorable Justice Shah clarified twice, I think, once in his address this morning, that in Indira Sahni itself, Honorable Supreme Court has clarified the reservation for the persons with disabilities justified in Articles 16(1) of the Constitutions. And if you look at this judgment's para 30-32, then a detailed description comes how this would operate when the logic of horizontal reservation code talks about, and gives a formula which is known as a matrix roster. It's a three-dimensional matrix roster where reservation for the disabled and, for example, like servicemen is interlocked into the vertical categories which are SC, ST, OBC in general. And the administrative rules, fortunately, in this regard are very well and developed and quite clear. And they say that, for instance, when meritless a separate merit list is drawn of disabled candidates who are to be reserved against 3% vacancies. Then, in that merit list, we will look at the main category of the disabled. For example, if on the top of the merit list a disabled candidate belongs also to the category, for example, OBC, then this person will occupy a reserved roster point meant for OBCs, which means that the reservation is not as if it is 3% of general, 3% of OBC and 3% of SC. No, it is 3% overall in 103 vacancies, but depending on to which category the disabled belongs, because a disabled will belong to one of the categories, SC, SC or BC or general. So that roster point earmarked for that category would be utilized in effecting the reservation. So that way the stipulated limit of 50% does not, is never crossed. That's a rule. But,
the speaker is quite right.
Justice Vikramjit Singh, I wanted to just...
Can we finish this
sure.
this particular topic?
One second. Mr. Anuradha, please introduce yourself. Many of them would like to know. Your enlightening is all right. Other members may not know. Please say about you. And then
No, please let us have your introduction first, then we'll go on to the next.
Sorry, I should. My name is Anuradha Mohit. I have a small but an important job of assisting the Commission in my capacity as a special rapporteur on disability. And I dealt with the disability cases in a very large number in my previous job as a Deputy Chief Commissioner, which has a complaints procedure. So some of it will come from that experience also.
I want to add not a small role. She is playing a very, very vital role as a special reporter to NHRC, and her services are recognized in international level. She has contributed greatly for the disability manual, which you will be having shortly. Yes, Mr.
I agree entirely with the intervention. I have the passage here, which is in front of me from Indra Sani. She has mentioned it already. It reads as follows. However, reservations for individuals are permissible under Clause 1 on a ground other than economic, provided, of course, the ground is not hit by Article 16(2). Instances of such individuals have been given earlier, which need not be repeated here. There is, however, no need to make additional reservations for such individuals over and above those made under Clause 4. Justice Shah had also mentioned there. The individuals can be accommodated in the quota reserved for the backward or in the unreserved or general categories, depending upon the class to which they belong. For example, the defense personnel and freedom fighters or their dependents, physically handicapped, etc. Can be accommodated in the reserve quota under Article 16(4) if they belong to the backward classes, and in the unreserved post appointments if they belong to the unreserved category. This is so because in their respective classes they will be more disadvantaged than others belonging to those classes. That is what my response to Professor was. That when you're looking at scheduled castes and scheduled tribes, why should you not first accommodate the more disadvantaged in that already disadvantaged group? I don't think my effort was to say that no, these rights should not be given to the scheduled caste, scheduled tribe. Right? My emphasis was let's look after them with greater care than the others within that group.
So does it mean that it's a class within the class? Yeah. In the reserved category.
Yes, Justice Saikia, you wanted to ask. Please introduce yourself and then put it.
I am Aftab Hussain Saikia. I am representing Guwahati High Court. On my behalf and on behalf of Guwahati High Court, I offer heartfelt thanks to the organization for inviting us to this. I would like to share my experience on this PWD Act in my High Court. One petitioner came before this court, my court, complaining that he was a handicapped person. He was suffering from traumatic paralysis on left hand. But in spite of his repeated requests to the authorities, verbal and writings, he was not accommodated in any service. Ultimately, he was given an appointment on contractual basis in grade 3 as surveillance worker under a district malaria officer in a district known to be Sonitpur. He was given 30 days time for contract basis, and time till then extended. And one time, after 1996, he was denied that appointment also. So they approached this court, alleging that he has been denied because he was disabled due to his paralytic conditions, which was 60% disability. Then court asked the government whether any scheme has been made in this purpose under section 34. The government has come up fairly with the statement that so far the serious steps is taken for implementation of the Act, and they have published the scheme. But that scheme was only for the blindness. But no such scheme has been made by the government of Assam as regards the locomotor disability, with the present case phase 2. So ultimately, after hearing about the parties, also taking into account the various provisions of the Act, also those constitutional provisions in the light of the international treaties, court has directed the government to make a scheme also to accommodate that. Ultimately, today's position scheme has been made so for locomotor disability person, and this person accommodated. And this has not been appealed and it is now sustained. That is the experience I am having. So in my case,
Positive contribution is appreciated.
thank you, sir.
Yes. With the leave of the chair, I would like to revert to the subject. I am Girish Gupta from Calcutta.
That would be good, yes.
Actually, in the Indira Sahni's case, earlier it was held that 50% is the outer limit for reservation, and that was in the case of Balaji. In the Indira Sahni's case, that view was dissented from. It was specifically, I will read out that sentence. It was specifically held that this view is not accepted. The sentence says, reservation should be less than 50%. How much less than 50% would depend upon the relevant prevailing circumstances. This was the view expressed in Balaji's case. And with regard to the 50%, it was held that if the population is 80% and the object is to give them adequate representation, then the reservation can be 80% and 50% was dissented from. Subsequently, in the 16(4)(a), the concept of 50% has been added. And moreover, in the Indira Sahni's case, the concept of disability was not before the court. With regard to physical disability and this 3% reservation, this act came subsequently. Therefore, we should not think that the judgment in the case of Indira Sahni has anything to do with this reservation subsequently introduced.
Can I just, because this issue was specifically raised by Mr. Rungta. He wanted to contend that the disabled persons are part of backward classes. On that, the Supreme Court said that there can be a positive discrimination in favor of disabled. To that extent, that judgment is relevant. But you are right, that 3% etc. that came later. The Supreme Court merely said that there can be a reservation for the disabled persons in the education as well as the employment.
As far as the judgments are concerned, I think we will not discuss judgments. The judgments are before us. We are all are literate in judiciary. That's why I will read what the judgments are. If anything which is not covered by judgment, please welcome to ask. Otherwise, reading a judgment or understanding a judgment is we can do better peacefully and calmly when the occasion arises. Yes.
May I see your
Yes, sir. Justice.
I am Bilal Nasti from Andhra Pradesh. The difficulty suffered by implementation of this act, which we have experienced, is that it helps those who are less disadvantaged. For instance, take visually handicapped. 40% visually handicapped is also disabled. 100% blind person is also disadvantaged. 40% and 100% is in one class. Similarly for locomotive disability. When they compete each other, 40% is blind is a person who can read and write with corrective reflections. He can see the objects. He can recognize people. He can walk on roads. 100% blind is a blind person. In competition, 40% invariably defeats the 100% blind. So we take their comparative merit when we offer them the jobs. Invariably, it's my experience, 40%, 50%, 60%. They are higher up in the merit than 100% blind person. So whom we are helping? It's a very interesting question. We cannot have a class within the class again, all blind persons, 40% to 100%, or blind persons. So when you give the job not to the worst, but you give the job to the best amongst worst. That's an anomaly. This act, I have felt, physically handicapped also. See a person with a back injury, he can't move his limbs. But see a person with polio man is always generally better in merit than the other person. So 100% disability people are not able to get the benefit out of this 3%. It is partially disabled persons who are taking a march over the totally disabled persons. Thank you.
That question had come up in a case, the one which I had mentioned, Dr. Raman Khanna. The rule of the MCI, the Medical Council of India, they reckon the disability from 50% onwards. That was challenged. That the Act says it is 40%, why are you going to 50%? I think, I'm not sure whether you are saying that the preference should be given to more handicapped, to the higher percentage.
I am not suggesting anything, that's for others to decide. I am saying what is the difficulty. The total blind person is not getting the job under reservation, partially blind person is getting.
So are you saying that
I don't say anything, that's not my job. That is job of somebody else.
Justice Nesky, we understand you saying that though this reservation is made for these persons with disability, persons with greater disadvantage suffer, and the person with a lesser disadvantage within the same class gets advantage.
Yes, should have been reversed.
That's right. What you say, because if all things being equal, certainly persons with greater disadvantage can be given. But if the question of merit comes up into the same class, you can't make a class within the class. That appears to be the practical experience or the difficulty that you are facing. And now you tell, you have posed this question as to what is to be done in this regard. You have not said anything, but Justice Sen is trying to.
I'll just clarify. This was a case which we decided also in Andhra Pradesh, but we could not help those.
That's right.
When we saw the merit list, 40% blind persons were above the 100% people.
I hope you must have made certain observations in this regard for the guidance.
We made only observation, please change the law.
That's right. That's right. That's what we thought so much. Must the pious folks or observations are there, legislature should take note of it. Let us see. We have another 5 to 10 minutes and thereafter we have to move on. Yes, please.
I am Shomitra Paul from Calcutta High Court. Recently we experienced that a pregnant lady who was undergoing a primary teacher's training was told not to continue pursue his education of his course, and he was taken off the rolls. So my question is, since it fell from Justice Sen that disability must be given a wider meaning, do these ladies, they come within this pregnancy shall come within this wider meaning of disability? For that disability, yes. I am asking for that question for that period also. For that period. I would like to point out, and it was stuck up from the rolls.
I think maternity law should take care of.
In the case of Nargis Media, this question has been taken care of.
Any other question, please?
Excuse me, sir, may I ask a question?
Yes.
My name is Radhika Alkazi and I work with a non-government organization working with people with disability. I just want to make 1 or 2 points. One, of course, is that we do know that people with disability are largely poor people in our country. The relationship of disability and poverty is very close. Secondly, the census does show that the significant proportion of people with disability also belongs to the Schedule Caste and Schedule Tribes and other backward classes. Thirdly, I wanted to ask really, Justice Vikramjit Sen had spoken about the 3% reservation and how probably there could be a broader interpretation. There are other people within the Disability Act. I'm talking of people with mental disability. And I'm wondering whether we need to look at the Act from the point of view of some of these people and whether the reservation in terms of educational institutions and jobs could be applied to people with mental disability. Because there are posts in the government, there are categories, the C&D categories and others, which people with mental disability could take up. But that has not been the case till now. So I'm just wondering whether that's a possibility. Whether we can ask for this.
There are 2 different sections. So far as the benefit for admissions are concerned, Supreme Court has already said you read both sections and it will apply to them. 39 applies to admissions. Section 39 applies to admissions in educational institutions also. So that point of it has already been clarified. So far as, if I understand your earlier question was, I had put forward the thesis that we can go beyond the Act, go behind it, go into the Constitution. Every law has to be tested against the Constitution. And if there is an equality which the judge perceives, I would say you have to. We are not civil law country. We have to decide the matter. We have to decide the issue. So if left to me, I would say you have to go back, give the benefit. Unlike my learned brother, I had held, and that view has not been overruled, that why can you not form categories of 50% to 60% disability, 60% to 70% disability, and then equate them mark for. Of course, there is a question of a class within a class, but it's a matter which has to be grappled with.
I would like that.
Yes, Mr. Colin.
So this is my name is Colin Gonsalves. I'm one of the organizers. So I have a comment and a question. The comment relates to the definition in the Disabilities Act where certain categories of disability are not enumerated. For example, you won't find hemophilia, you won't find thalassemia, and many of the disability groups are actually quite distressed that they stand on the same footing but they're not included in the Act. I had a chance to come across a Canadian Supreme Court decision in Elridge's case, where the Canadian Supreme Court talked about the doctrine of under-inclusiveness in a disability case, interpreting the Canadian Disabilities Act. and said that if you have disability including A, B, C, D, and you leave out E, it can, by judicial interpretation, something equivalent to the Equality Clause, be brought into and read into the Disabilities Act. That's one. That's the comment that I could we follow a similar practice here at some stage. The second was in respect of the controversy relating to the powers of the Commissioner. We have a very distressing situation right across the country where governments, state governments and the central government also, confronted with the orders of the Disability Commissioner, say that they're not binding. So you go through a whole process of adjudication, so to speak, and ultimately the governments themselves disown the orders of the Commissioner. What attitude would the courts take in such circumstances?
Whether such an issue has been the subject matter of any judicial interpretation?
No, this issue came before us. The petition, the matter has not been decided, but the prayer was that that a disabled person should be appointed as a commissioner. The advisor to President George Bush is a disabled person on the disability issue, and because of his presence in the President's office, the disability movement has taken strides in America. So on that basis, a prayer is made. Petition is still pending, but at least a person who is conversant with or who is familiar in the field of disability, who has some experience, should be appointed as a. I think that to that extent, a decision, possibly the government can be directed, because otherwise it is like any other job. I mean, the secretaries are transferred from one post to another. Similarly, one secretary is picked as a commissioner.
I am Justice Jayant Patel. I hope the question is that whether the direction of the commission is binding to the state government.
The question is whether the directions or decisions made by the commissioners appointed for this purpose are binding on the government. All of that. And of course, the commissioners appointed by the respective governments, in the ordinary course, government should accept and they must be binding. If they do not accept them, I think the ways are very clear. Armed with their orders, one can reach the judiciary and judiciary will accept them. That all that can be done. As on today, there is no suggestion of this.
Well, I may share my experience that I have taken the view that the decision of the commissioner is binding to the state government. When the case arose before me, one of the students who was not admitted, and ultimately on the basis of the directions of the commission, the mandamus was issued to the state government.
And that decision, no appeal against them?
No, it has been accepted by the
government. Let us hope that decision prevails for other purpose.
A small area.
Now it is a time to move on for the other subject. We had very useful intervention and good comments and good opinions for the benefit of all. Thank you.
Justice Sanjay Kishan Kaul is currently a judge in the Delhi High Court. He practiced in the Delhi courts for nearly 20 years in various areas of law as advocate on record of Supreme Court of India and later as designated senior counsel. He was elevated as a judge of the Delhi High Court in May 2001 and has been delivering very positive judgments on disability rights. I now invite Justice Kaul to speak on the landmark judgments under the Disabilities Act.
Good morning, brother judges, ladies and gentlemen. First, let me apologize for not being here in the morning, but I was given to understand through the time-slotted discussion, and my time would begin at 11:30. So that's how there was some mistake, and I had some prior commitments, so I didn't realize that I had to join in earlier. May I begin with there is a quote by John Adams. It says, "The law will not bend to uncertain wishes, imaginations, and wanton tempers of men. On the one hand, it is inexorable to the cries of lamentations of the prisoners. On the other, it is deaf as an adder to the clamor of the populace." the whole law on disability protection has come slowly as the glamour has grown. Disability initially had to be recognized as something which I was just as Sen said is fundamental and began from the very beginning. It's not something which has come into being in the last couple of years, the last couple of decades. It is inherent. It may arise from birth, it may arise from situations which may develop during their lifetime, and thus it is something which has been in existence for a considerable period of time. You may have, as said, physical and mental or psychological disabilities, and people acquire them at times during the currency of their life. We have 1/10 of the population of the world which is constrained by these parameters. And if one was to consider the benefit as under the Act, and I'll then go on to some of the judgments which have been delivered and the ramification of it, we are looking to different fields of education as the first, which is the beginning, how to educate people in this field. Whether the Act takes care of, our Acts take care of a situation where we are only looking to particular kind of disabilities only. Do we take care of other kinds of non-recognized disabilities here in respect of education? Then we come to the issue of employment. We come to the social requirements. The social requirements arising from housing in metropolises and other places, of social securities, of social dangers where such people are not able to protect their existences in life, and how the society and the Act is helping in that process. Now, starting from the issue of education, and to some extent education and employment, I would say, are interlinked factors. These are the two, according to me, the most important factors to the beginning and where emphasis has to be laid. In this behalf of education and employment, I want to emphasize one fact. So far, the attempt has been that it is the government which has to come up with support system, and how much it has come up, we'll see as to how attempts, to my mind, have been made, attempts to completely defeat. And I had some judicial experience of scrutinizing such a case where I thought everything was done to see that it is not implemented. And the other issue is arising from the declining role of the government in the society. If this declining role of the government is taken into account, how do we cater to this populace which is there in the large growing private sector? This is a normal general aspect which is coming up of privatization.